Tribal nations have long been leaders in the field of sovereignty rights and environmental rights. Most recently, there has been a surge of lawmaking around the recognition of environmental rights for tribal members and the rights of nature and ecosystems. In 2016, the Ho-Chunk tribe in Wisconsin became the first tribe in the United States to vote to amend their tribal constitution with the rights of nature. In 2018, the Business Committee of the White Earth Ojibwe Nation in Minnesota recognized the rights of wild rice and environmental rights of tribal members. Other tribes voting to recognize the rights of nature and the intertwined rights of tribal members include the Menominee Nation in Wisconsin, Ponca Nation in Oklahoma, the Nez Perce tribe in Idaho, and the Yurok Tribe in California. It is my pleasure to moderate this First Nations panel with Dean Elizabeth Kronk Warner of the S.J. Quinney College of Law at the University of Utah, and Geneva E. Thompson, Associate General Counsel for the Yurok Tribe Office of the Tribal Attorney. So we'll hear from Dean Warner first. There'll be two presentations, first from Dean Warner and then second from Geneva Thompson. Then we're going to have some dialogue around moderator questions, finally finishing up with questions asked by the attendees. So we'll hear from Dean Warner first. Her curriculum vitae is 14 pages long, so to cover it would likely take up most of the time that we have for the whole panel. But in summary, Dean Warner is a nationally recognized expert in the intersection of environmental and Indian law and has 40 articles and book chapters to her credit. She's a citizen of the Sault Ste. Marie tribe of Chippewa Indians and has served as the chief appellate judge of the tribe's Court of Appeals. It is my distinct pleasure to give you Dean Elizabeth Kronk Warner.
Thank you so much. I very much appreciate it. And it is just a pleasure and honor to be with you here today. My pronouns are she and hers, and I always like to start presentations and discussions by acknowledging that at least where I'm at, which is the Salt Lake City Valley here in Utah, that we are on land that was traditionally indigenous land, Shoshone, Goshute, Paiute, Navajo, indigenous peoples would typically come to this area. And it was a location where they would meet and gather and have ceremonies. So it seems particularly relevant that we should be, at least I am here today to gather and participate in this discussion. I very much appreciate the opportunity to do so. I also want to thank you, a big thank you to Widener University, to Dignity Rights International, and to the Center for Democratic and Environmental Rights to host this conversation. I think it's a really interesting conversation. It's certainly an area that is, for lack of a better term, cutting edge. And so I appreciate the opportunity to meet and to discuss these issues and to learn from each other. So thank you so much for including me. I very much appreciate it. I also want to acknowledge something that is important for me as an Indigenous person, which is the fact that this panel, I noticed on the agenda, is framed between two other panels that explore sovereign rights. And so I really appreciate the implicit recognition of sovereignty that is inherent in the program's agenda, and recognizing that tribes, just like countries in Latin America and other parts of the globe that are being explored through this conference, are sovereigns and should be treated as such. So a big thank you for the implicit recognition of tribal sovereignty that is present in today's presentations. There's a couple of things that I want to talk about today in my remaining 9 minutes or so. Which is talking more broadly about how, and the focus of my presentation will be rights to the human environment, about how those rights can be expressed for tribes, or how tribes may want to express those rights. And so I'm going to talk about environmental law as it's generally applicable in Indian country, and talk about the different forms of environmental law, and then give some specific examples of how we're seeing these rights to an environment, specifically in relation to humans in tribal law. You got a great example. Thomas gave us a great example at the beginning when he mentioned several tribes who have done this through revision of their constitution and other mechanisms. And we can talk through some other examples as well throughout the presentation. So first, just so everybody is familiarized themselves with the law that is applicable in Indian country, and specifically the environmental law that's applicable in Indian country, I thought it would really be helpful to talk about how three types of law intertwine in Indian country. So you have tribal law, you have federal law, federal from the United States government, and then sometimes, although not often, you may have state law. So that's kind of the giveaway, is we're not going to spend a lot of time talking about states, because in general, states do not have the ability to express their laws in Indian country unless Congress has specifically given them the ability to do so, or there's potentially a non-Indian contractor that a state may tax or regulate. But in general, the states are not big players in this sphere. So when we're talking about tribal sovereignty, we're talking about the inherent sovereignty that tribes possess over their citizens and tribal lands. And one thing that is a common misconception among many Americans is that tribal sovereignty still exists today. It has been limited by the US Supreme Court in certain ways and by Congress, but it remains to this day. And that is the presumption we start with. We presume that tribal sovereignty persists, and we presume that tribes have this authority over their individual citizens and territories. And of course, that's very relevant and important to our discussion of the right to the human environment, because tribes have a lot of authority and say over what they can do with regards to their citizens and their territories. Tribes can enact laws that guarantee the right to a healthy environment. And again, Thomas gave us some really great examples of tribes who have done that, and tribes who are actively in the process either of revising their tribal constitutions, and that's an important point too. Many tribes do have constitutions, and they can also do it through statutory law. So many tribes have statutes specifically related to environmental provisions as well, in addition to constitutional provisions. The one thing that is perhaps helpful to know is, notice that when I talk about tribal inherent sovereignty, I've been talking about tribal citizens and tribal lands. Things get a bit more murky when you are talking about non-Indians that are located on non-Indian land within Indian country. And in general, in those circumstances, the presumption does reverse. And so that's a case from United States versus Montana that says that tribes have been implicitly divested of their sovereignty over non-Indians on non-Indian land, but two exceptions apply. The first is if there's a consensual agreement. So certainly you could agree to be governed by the tribe, and some entities do. But for our purposes, I think more interesting is the second Montana exception, which says that tribes may exert authority where somebody's actions have the capacity or the potential to threaten the health, safety, or welfare of tribes. And importantly, courts have interpreted that language to be applicable in the environmental context. So where you potentially have a non-Indian actor acting in a way that threatens the environment of the tribe could potentially, under the Montana case law and line of cases, have the ability to regulate and adjudicate that individual's activities. So that's the status of tribal law. So again, tribes generally have authority over their citizens and tribal territories, and could have authority over non-Indians acting on non-Indian land if it threatens their health, safety, and welfare, which I think we could make an argument in the environmental context that certainly could happen. Federal law could also potentially play a role. So the federal government has enacted numerous environmental statutes, especially between 1970 and 1990, that have been held to be statutes of general applicability and therefore applicable in Indian country. So these include things like the Clean Water Act, the Clean Air Act, the Safe Drinking Water Act. Those all apply in Indian country. But what's really important about those federal statutes is that they contain, many of them contain, provisions called Tribes as States, or TAS provisions. And the importance of TAS provisions is that tribes can utilize that federal law and adopt their tribal specific provisions that allow for them to protect their environment. So they can actually utilize and kind of weaponize, if you will, federal law in a way that protects their environment, that's consistent consistent with their tribal ethics. So for example, the Clean Water Act has a TAS provision, which allows for tribes to define what the delegated purpose of their tribal water quality will be. So for tribes who through tribal law have said that water quality should be of a certain level, either for the human environment or sometimes tribes will do this for the cultural and spiritual environment, they can designate a more protective water criteria under TAS status of the Clean Water Act that helps them effectuate that right to a healthy environment. So the TAS provision can be very helpful for tribes who want to use it in order to promote their own laws or to further their own laws and ethics which call for this protection of the environment. So let's talk a little bit about how that works out in progress in practice in my remaining couple of minutes. So first, I want to give you an example of tribes utilizing their inherent sovereignty in this context of the right to a human environment. And this is a really good area where we see this is in the area of climate change. This is an area where the federal government, at least to date, is not regulating in a holistic manner. We do not have any federal statute that applies to tribes, and so therefore tribes are free under their inherent tribal sovereignty to enact laws related to climate change adaptation and mitigation as they please. And we have seen tribes doing this. Tribes are doing incredibly innovative and wonderful things. And I'll just give the example of the Confederated Salish and Kootenai tribes, which I highlight for two reasons. The first is the Confederated Salish and Kootenai tribes tribal adaptation plan specifically references this need to create a plan and to engage in adaptation in order to protect both the human and the cultural environment. And in reaching that goal, it's interesting because they identify the cultural resources for the tribes that are important for their cultural survival and their cultural sovereignty. And then the climate change adaptation plan goes on to provide a hierarchy of how, recognizing that the tribe is not in a place and does not have the capacity to necessarily protect all those resources at the level at which it would desire to do so, it creates a hierarchy through which it can mesh the needs of the human environment and the cultural environment in a way that I think is very provocative and progressive. Second, I raised the example of the Confederate Salish and Kootenai's climate change adaptation plan because another thing that I really enjoy about it, encourage you to look at if you have an opportunity, is it incorporates traditional ecological knowledge. So the tribe actually went out to its elders, did interviews, and the transcripts, relevant portions of the transcripts, are included in the tribal adaptation policy to show not only how we need to protect certain resources for the human environment, also for the cultural environment, but using that traditional ecological knowledge and their long time history and knowledge of the area to talk about how that can best be served. So I think that the Confederated Salish and Kootenai's tribal adaptation plan is a wonderful example of how tribes are utilizing their inherent tribal sovereignty to protect their resources, both for the human environment and for purposes of cultural sovereignty. So with that, I will end, and I look forward to further discussions.
Great. Thank you, Dean Warner. I think that I've been doing this work for about 25 years. I think that was the best 4-minute thumbnail overview of tribal law jurisdiction that I've heard over the last 25 years. So thank you for that. Our second panelist today is Geneva E. Thompson. Geneva is a citizen of the Cherokee Nation and Associate General Counsel for the Yurok Tribe in Northern California. She's a board member of the National Native American Bar Association and a delegate to the American Bar Association Young Lawyers Division Assembly. Her legal practice includes environmental and cultural resource protection, advocacy, and litigation in tribal, state, and federal fora. It's my pleasure to give you Geneva Thompson.
Hello, thank you. I'm going to see if I can share my screen so I can pull up my PowerPoint real quick. Let's see. Here we go. There we go. All right. Well, hello, OCO and IOQ. My name is Geneva E. Thompson. My preferred pronouns are she, her, and hers. And as Thomas said, I'm a citizen of the Cherokee Nation and also Associate General Counsel for the Yurok Tribe. I'm currently presenting from Yurok Territory here in Northern California, which is the bordering nation to the Yurok Tribe. And I wanted to thank the panelist organizers for having me here today. And also I want to thank Dean Warner for that great recap of federal Indian law and tribal law and how tribes can implement tribal law to protect their environment and natural resources. So I have the honor today to present to you all about a new law that the Yurok Tribe is currently drafting to protect the rights of the Klamath River. So as a quick disclaimer, we are still in our legislative process in developing the rights of the Klamath River Ordinance. And so as we move through our legislative process, different things might present itself that might be different from this presentation today. And so I just wanted to give people heads up that we are still going through that process and that the statements and opinions are subject to change. As a quick presentation outline, I hope to go through on why the Yurok Tribe has decided to codify the rights of the Klamath River, how the Yurok Tribe is implementing this legal framework, and also what is included in this new law. So first on the why, the Yurok worldview on protecting Yurok natural resources is pretty encompassing, and you can find the statement in the Yurok Tribe's Constitution and Preamble where it states the Yurok worldview of its natural resources and how the people live within those natural resources as an integral piece of the natural environment. And so you'll see that this ethic and worldview is throughout all of the tribe's laws and policies, and how the Yurok government governs its not only the lands found within the Yurok Tribe's reservation, but also the lands throughout the Yurok Ancestral Territory, which is a much bigger area than the reservation that the Yurok Tribe is currently on. Weeroy is the Yurok word for the Klamath River, and since time immemorial, the Yurok Tribe and its members have lived along the banks of Weeroy and have all of their lifeways intertwined with the health and ecosystem of the river. Specifically, one piece of the river that is significantly important to the Yurok people are the salmon. And I've quickly put up here a quote from one of our Yurok elders, Suzanne Matson, where she describes the importance of the salmon to herself and the Yurok people. As you can see in the bottom of this of the slide, you can see the citation to her interview where she talks about the importance of the salmon. And I thought that was really important to share with you all, so you can see where she's coming from as a Yurok member. But essentially the salmon, as a very important component of the Klamath River, is essential for the Yurok people's ability to live and thrive, not only physically, but culturally and spiritually. And so when we started thinking about the rights of the Klamath River, the salmon and protection of the salmon was a key piece of what the Yurok law needed to do to not only protect the ecosystem, the river itself, but also the Yurok people and the Yurok Tribe. And so how is the Yurok Tribe implementing this new law? First, Resolution 1940 was adopted by the Yurok Tribal Council that laid out the expression of the government that the Klamath River is not only to be protected, but has its own legal rights as an entity under Yurok law. And through this resolution, the Yurok Tribal Council declared that the survival and protection of the river is also central to the survival of the Yurok people and the Yurok Tribe, and that the Yurok tribal government is going to do everything it can to protect the Klamath River. Also in this resolution, my office, the Office of the Tribal Attorney, was directed to draft an ordinance which would detail out all of the mechanics of this law and really establish how the Yurok Tribe is going to enforce the rights of the Klamath River. So as I mentioned in the beginning of our presentation, we are still currently in this drafting process. And every time I touch this project, it grows. And so it is quite an undertaking, but it's been very exciting. So we're doing in-depth legal review, working with our different departments. We have a robust fisheries department, our environmental program. We have our wildlife department that works a lot with other species outside of the fisheries department, and gathering all of their scientific insight and cultural insight on how this law can best protect the river and its own sake. We're doing many stakeholder meetings where we're meeting with Yurok community members and elders and working hand in hand with the Yurok Tribal Council. And the last task that I think is probably one of the biggest tasks that my office is taking on right now is really developing our environmental and cultural enforcement infrastructure. So how are we as a government going to enforce the rights of the Klamath River in tribal court, potentially in state or federal court? And so we're doing a very in-depth review about how our enforcement infrastructure is going to look like in reference to this new law. So what is included in this law? First, we provide a robust definition of reroy, which is important because how we define the Klamath River is going to set the boundaries of where this, how we can enforce this new law. And so we're trying to be as inclusive as possible with the understanding that the bigger the boundary is, potentially different difficulties in enforcing our law. And so we foresee enforcing this law in very different ways and might have to utilize other sister jurisdiction laws, including the state of California and the United States laws, to help enforce this, this new tribal law. I put up a picture of the Klamath River Basin so you all could fully see what our law is defining reroy as, and it is the full river basin from southern Oregon to northern California. As you all can see in the bottom left, there's a yellow line that follows the river. That yellow line is the Yurok Reservation, and then the yellow square attached to it is the Hoopa Reservation. And so as you all can see, and as Dean Warren explained, jurisdiction varies depending on what properties you're on. And so we're trying to keep that in mind when we're developing our rights of the Klamath River law. So also in the rights of the Klamath River Ordinance, we're providing a robust definition of a cultural riverscape. So it's similar to a cultural landscape, but where it's the idea that the river and its viros are cultural and natural resources that are associated with historic events, activities, or persons, or exhibiting other cultural or aesthetic values that are significant to the Yurok people. And so the idea here is by providing a robust definition of a cultural riverscape, we will then be able to trigger the National Historic Preservation Act and the California equivalent laws in order to use our sister jurisdictions laws to help protect the Klamath River. And so that's what we're trying to do, is integrate our law into the other systems that we find ourselves in. The purpose of the law is not only to exercise the Yurok Tribe's inherent sovereignty to protect the Klamath River, but it's also to ensure the Klamath River can exist, flourish, evolve, and have a clean, healthy environment for the river's sake. It's also to provide a legal basis to protect the Klamath River as in the multiple jurisdictions as discussed. And it's also to grant the Klamath River standing in causes of action. And so we think this one's very important because there are times when the river itself should have standing to best protect its rights. And so we see that by granting the river standing and having the right to move through Yurok courts or any other courts on its own basis will lead to extra protections that might not be available if the river itself did not have standing. Further, the ordinance is going into in-depth rights of the Klamath River. And so this is just a couple that we are fleshing out right now in our ordinance. But again, every time I touch this law, it grows. So we are working on many other rights for the Klamath River. But essentially the idea is if a party violates any of the rights set out in the ordinance, then that entity or person can be found liable under the new law. Our law is also going to detail the rights of the Yurok people to not only protect the Klamath River, but to practice cultural ways of life in relationship to that river. And here we see it as kind of in hand. So the river, the Klamath River, could not be the river it is today without the Yurok people, and vice versa. The Yurok people could not be who they are without the river. And so there is a intertwined understanding of the rights of the river and the people and how they are interconnected. And this law, and I really view that as, and many people view that as a Yurok common law. And so the idea of this rights to the Klamath River is we really are just codifying that common law. And by writing it down and having this ordinance really spell it all out will help my office ensure and protect those rights and that common law, especially for folks who might not be Yurok and might not fully understand the common law. Having it codified helps with that protection. Further, this ordinance is going to detail the rights of the Yurok Tribe as a government entity, not only to protect the river and its people, but also the right to regulate. And again, the right to regulate is already there. It's not like we're creating a new right, but we are further codifying it to help with enforcement and clarity. And then lastly, our ordinance is going to go through the Yurok court jurisdiction, which Dean Warner already discussed a lot, so I will not harp on that. But that's what our ordinance is going to do, is to really focus in on our jurisdiction and those 2 Montana exceptions. So with that, thank you so much, and I'm really looking forward to our conversation. Otto.
Great. Thank you, Geneva. And I want to just say thank you not only for working on the law, but also being on the speaking tour to talk about it I know you did a California University recently, and also the Tribal Environmental Law Summit to speak to other folks about what the Yurok Tribe has been doing. So the great news is I have you two to myself for 20 minutes, and I have a bunch of questions to ask, some which are macro, so 30,000 foot level, and others that are very, very specific about jurisdictional stuff. So starting at that high level, I'd like to ask Dean Warner, start with Dean Warner, a question about rights, just the word itself, that rights themselves are a Western law concept. And in speaking with tribes and tribal members over the last 20 years, there's been some opposition to even using the word rights or the concept of rights, because tribal nations don't necessarily think in terms of, not to lump everybody together, but don't necessarily think in terms of rights. So how do you talk about the concept? Do you embrace driving indigenous values into a rights system using that rights vehicle? But how do you talk about right to a healthy environment from that perspective?
Yes, thank you. And that's absolutely correct in terms of there is no monolithic tribal perspective on this, as Thomas correctly pointed out. So Thomas is absolutely correct that many tribes, including the Confederated Salish and Kootenai tribes that I mentioned earlier, do speak not in terms of an individual right, which I think is how we typically talk about it, at least in the United States, as an individual right to a healthy environment, but rather it's specifically framed as a community right. And I think that's an important differential. Many tribes, not all, as Thomas correctly pointed out, and I appreciated that he did point out that there are differences. I think sometimes there's this stereotype of tribes as the environmental steward, and that we somehow all have the same views on things, and certainly we do not. It is important to acknowledge that some tribes have adopted and adapted a very similar governing system to what the United States have, where they do speak in terms of individual rights. And they have revised their constitutions and documents to speak in terms of individual rights. So it is important to acknowledge that some tribes do in fact have a very similar system. But many tribes do also talk about this community right. And it's important too. One thing I wanted to add, and I saw that there's been some discussion in the chat about what's happening in other countries with indigenous populations. And you have not only the domestic laws of the nations, but you of course also have these international rights, which the Declaration of the Rights of Indigenous Peoples do again use that term rights. But when we talk about it, again, you really see the right of the indigenous community in that international declaration. You don't see a discussion of the individual rights of community members, but rather the community. Like, for example, Article 25 of the UN Declaration on the Rights of Indigenous Peoples talk about the right to maintain and strengthen their collective spiritual relationship with their traditionally owned and otherwise occupied lands, right? Which intersects really clearly with the right to the clean and healthful environment. Not an individual right that individuals of the community hold, but rather rights that the community, the indigenous community as themselves hold. So I think we see this, I would say that the majority of tribes who are looking at this issue, at least in the research I've done, and of course it's possible that I have not looked at enough, that's always a possibility, but at the tribes that I have looked at, most tribes do talk in terms of community rights and what right the community has to an environment. Some tribes have even, as Geneva pointed out, gone so far as to say that certain cultural resources, salmon and fisheries come up a lot, have certain rights as well. But it's more rare to see, at least with tribes in the United States, talking about rights in terms of individual rights. And to be honest, that's a source of conflict. I don't know if Geneva, working for a tribe, has had this experience, but it is not at all uncommon for tribes to find themselves being sued by tribal members who disagree perhaps with what the community right is and the direction that the community is going versus the individual. So that's an issue that we sometimes have to deal with in our individual communities. But many of the tribes who are doing this work are talking about it in terms of community rights rather than individual rights.
Yeah, Geneva, I had the same question for you. Have you run up against that kind of, it's almost a theoretical thing, but it moves very quickly from being theoretical to being very real in a context of disputes. So have you run into the same obstacles or challenges in talking rights language with the tribal members?
Yeah, I think it's an interesting question. I think, at least in the context of the rights of the Klamath River, when we started initially talking about this new law, I was getting some pushback with the idea that a government could declare the rights of the river, because in the Yurok worldview, the river has rights. Not only does the river already have rights, but it's a higher entity than people or the government itself. And so the idea that a government could give rights to an entity that is much higher than the actual government seemed to conflict with the Yurok worldview. And so the way that I explain it to folks is, yes, the river has always had rights, and those rights are definitely senior to, whatever is happening in the human world. But that the fact that the Yurok tribe is codifying those rights helps the government protect the river in the venues and with the tools that the government has. And so, and after explaining that, then folks seem to get it and actually support this rights language and the codifying of the rights of the Klamath River. And so when I look at it, it's like we have a current reality that the Yurok tribe is in, regardless if we like it or not. Colonization has happened and continues to happen, and we are subject to federal laws and at times state laws that we may or may not agree with. By the tribe codifying Yurok understanding and Yurok common law helps the government navigate its current reality and take the tribe towards a future that the Yurok tribe wants to be in. And so we look at this law as not only reacting to our current situation, but also as a tool and a path moving towards where the tribal government wants to be in the future. And so that's kind of how I have that conversation with folks when we are talking about rights, specifically around rights of nature and rights of the Klamath River. We get similar pushback with the rights for cultural practice. The Yurok people have always had the right to practice their cultural lifeways. And that is not something that the government, can grant. The Yurok people have always had those. And so again, by talking about them in a codified written Western type law is just a way of giving an extra tool for the government to ensure the protection of those cultural rights. And so, for most people that makes sense and they're very supportive. I know it does conflict at times for actual real world and reality type living. And so that's kind of the myth about laws, I guess. They really are just tools of governments. And so just trying to be honest and open on that conversation seems to help.
So Geneva, sticking with you for a moment, we get a lot of questions sometimes about the genesis of the rights of nature laws. Like, how did it start? What was the request, or what was the push? Where did the push come from? And I think also, as a second prong to that, a lot of people think that these are just kind of choices that people make to say, wouldn't it be nice if we had something like this in place? But the plight of the salmon runs in the Klamath River especially, I don't think people understand how bad the situation is. And was that the genesis, or was there a different kind of battery power that began to run this?
Yeah, I think the start of this, it really is the impact that the federal government and state governments have been having on the salmon runs in the Klamath River is probably I hate to say the start of it, because I think the Yurok people have always viewed the Klamath River as having rights. But I think the dwindling population numbers of the salmon specifically, and the many years of the Yurok tribe trying to protect the salmon and trying to push back against other entities harming the salmon, led us to the place where, like, okay, well, what can we do under tribal law to help out? And so I think that's what started the idea of codifying the rights of the Klamath River. It's like, is there another tool that we can have in our toolbox to protect the river? And really, when the first request came in, it was just to look at the rights of salmon. And the more we thought about it, and more we looked into it, it's like that our laws would be better served if it was protective of a whole landscape instead of just individual species. And so we switched from individual species protection to landscape protection, because it allowed the tribe to have laws in place that would enhance the tribe's goals in protecting not only the salmon, but the Klamath River.
Great. So Dean Warner, back to you. So you wear a bunch of different hats in the tribal realm, in the law school realm. Have you seen over the years a shift kind of in the legal community, which is traditionally a very conservative community, to moving in the direction of kind of a new tribal jurisprudence around rights, whether that be rights of nature or a human right to a healthy environment, or, as you stated, a community right to a specific kind of environment or healthy environment? Have you seen a shift in legal circles towards those?
Yes, I think increasingly we're seeing tribes and tribal communities and indigenous communities around the world looking to law as a valuable partner. And I say a partner because I think law plays a role in this, but not necessarily the sole role. So as Geneva has described, Geneva and her team are doing a great way of codifying what was basically the community's customary law, right? Their understanding of the role and the rights of the river. And then law can be used as a tool to codify that and to perhaps make that customarily understanding of the role of the river have some really important legal weight, like she was talking about, giving it the river the right to have standing. So I see law and legal developments as being partners with Indigenous communities, because I think a lot of this work is already happening within the community and within the community partners, this either customary acknowledgement or a belief of what it should be. And so as lawyers and people who have knowledge of law as the tool, I think our role is to work with the tribal communities to think about what the goals are and how we can effectuate those goals. And sometimes I think the law leads, and sometimes I think the community leads. So a great example of I think the community leading was recently in the United States, the Dakota Access pipeline issue, where we really saw the community coming together, and not just the Standing Rock and Cheyenne River tribes, but also all Indigenous peoples. I did not have the opportunity to be there in person, but I heard from people who were there that there were Maoris from New Zealand and Aborigines from Australia. There are Indigenous peoples from all over the world who gathered there, and they pushed in their message. You might recall that their message was really this idea of water is life, and talking about water not only in terms of, it's a good example of the intersection of our two topics, right? Not only is water being necessary for human survival, but also that water has this identity as creator and mother in and of itself. And so water is literally the spiritual life to us all. And so I think that example of the community coming is a great example of these intertwining topics that we've been talking about today. And then we saw the law kind of follow along, right? So the community led and said that this is unacceptable for these reasons, and then we saw the law coming behind it. But in other instances, I think sometimes the law can help to lead. So I mentioned earlier that the federal government has not innovated within the space of environmental law, at least here in the United States, since the 1990s. And in the 1990s, they were amendments to existing federal laws. So we really haven't seen new federal environmental laws in the United States since the 1970s. And as a result, there is a huge legal void here that tribes are walking into. And I think what the Yurok Tribe and what Geneva and her team are doing is a great example of that, right? That we haven't seen federal and state leadership on this issue. So we have tribes saying this is something that's important, both for the human environment and for itself. And then we also see tribes really doing that in the tribal climate change adaptation area, where a wide variety of tribes have now jumped into this space to articulate what is their environmental ethical vision for what a tribal climate change adaptation plan should look like. And tribes, I argue, are actually, I think, becoming national, if not international leaders for what that adaptation can look like and how we can talk about climate change adaptation, not only from an individual perspective, but also from a community and a cultural sovereignty perspective, which you simply do not see in other aspects, at least, of American government, either at the state or at the federal level. So I think that the law plays a really important role, but what the role is can change based upon the circumstances. Law can either kind of follow behind the community. The community can say, this is our understanding of what the right to the environment should be. This is our collective understanding. This is our customary law. And the law can kind of follow behind and think about how to effectuate that and put that into play. Or sometimes we're seeing the law kind of lead in the tribal climate change space to become really being leaders within at least the United States, which I'll say isn't that difficult, given our federal government really hasn't done much since 1970. But we do see tribes really stepping up and becoming leaders in this space. So law has an important role to play, and what that role is will oftentimes be determined by the community itself and the issue at play.
So on that note, I want to get into the nitty-gritty of some of what you just said, and then go to Geneva for her thoughts on jurisdictional issues. It seems to me, at least, and I guess I'm being a little controversial here, but tribes are always on the losing end of the stick. When there's projects that are happening outside of reservation land that have real impacts on reservation land or tribal members, that you know, the agencies will use the word consultation basically just to check a box, say we need to consult with the tribes, and tribes put in comments, say this is really bad, we need to stop it. But then the project moves forward anyway. And the only thing, at least on the outside, you know, just in my opinion, that's really worked over the past couple of years is the civil disobedience piece, like Standing Rock, and folks who are in some ways in the least financial or other position to stand up and say, we're not going to allow this to come in. That seems to be the only thing really making a difference. And I guess the question I want to ask wrapped up in that comment is, these kinds of new laws, whether they're rights of nature laws or a right to healthy environment laws, they really only work if you can apply them outside of the jurisdiction that passes them. And I guess with the Montana case and, you know, the exception for a jurisdiction against non-tribal members if it's integral to the tribe's culture or cultural survival, that there's that exception in the Montana case. How do you see that playing out? Because most of the time when tribes pass these laws, they're not talking about themselves. They're talking about stuff that's happening off reservation land that's having an impact there. And just to make a long question longer, in Minnesota with the Ojibwe, White Earth, they passed the law recognizing rights of wild rice. Yet just north of the reservation, Enbridge is putting through an oil pipeline that's going to accelerate the climate change, which is going to extinguish the wild rice. So at some point, it seems to me that we have to generate or manufacture a new system of law that actually reaches outside the reservation boundaries. So am I off base, or is that pretty much?
No, you're hitting me in my Achilles heel with my argument. No, Thomas is absolutely right. That is the rub, as they might say. You know, as we started out our discussion of tribes do have inherent sovereignty over their citizens within their tribal jurisdictions. But once you get outside of those tribal jurisdictions, things get much more difficult to effectuate. And the reality is that oftentimes our communities are surrounded by people who might not share our same environmental ethics and views of the community. But all is not lost. Sometimes my students get really depressed and they say, how are we going to effectuate this change? But there are tools that are available to us. First, Thomas is absolutely correct. Sometimes when you're working with a community, the initial response should not be a legal one. And again, using the Dakota Access as an example is a wonderful example of that. So initially, the legal arguments were not successful. And I think it was ultimately an economic, just to be completely blunt, an economic reality that impacted that project and slowed it down in the concept of energy lost billions of dollars. And not only was the company itself affected, but also you may, some of you who are from the United States may recall that there was a huge movement of asking the banks who had invested in the project to divest themselves of that project. And so there was a real important economic component to that I think had real world implications, to the tune of, we've seen subsequent pipeline projects like the Ruby pipeline, which I think is the far other extreme of where the pipeline realized, hey, look, either we can do this in a cooperative way, or we can do it in a way that excludes tribes and tribal concerns to the tune of losing billions of dollars, having massive PR problems. And yeah, sure, maybe eventually at the end of the day, after years and years and years of litigation, we might get our pipeline through, but is it really worth it? And so we saw the companies who invested in the Ruby pipeline coming to the table and reaching out to tribes and saying, how do we do this consultation? How do we have you involved? And so I think that's a really important postscript to the Dakota Access example of sometimes companies, by reminding them of, hey, at the end of the day, you may legally win, right? You may accomplish what you want to accomplish, but at what cost? What will be the economic cost and what will be the PR cost? So I think that's an important tool. And then also in terms of legal tools, when we're talking about the impacts to extraterritoriality of the tribes, I think that's where the federal laws can be co-opted by tribes in a way to effectuate their goals. So again, the Clean Water Act is a great example. The seminal case examining the tribes of state provision of the Clean Water Act was the city of Albuquerque versus Carol Browner. And in that case, the American Environmental Protection Agency had approved the Pueblo's TAS provisions that were much more stringent than the city of Albuquerque. And this was on the river where the city of Albuquerque was upstream from the Pueblo. And so because the Pueblo had much more stringent water quality standards, the EPA said, hey, city of Albuquerque, you have to reduce your effluent pollution in your water because it's having negative impacts. It's precluding the ability of the Pueblo to meet its water designations. And that went up all the way up to the 10th Circuit. And ultimately the 10th Circuit said, yep, EPA, you're right. You can approve under the TAS provisions of the Clean Water Act, those more restrictive requirements. So as a result, the city of Albuquerque, of which the Pueblo had no jurisdiction over, had to limit its effluent and had to have cleaner water. And so I think that's a good example of how tribes can co-op and can use those federal laws to try to effectuate change off the reservation.
Great. Thank you, Dean Warner. So Geneva, I had a question, two-pronged again. One is about jurisdiction. So do you anticipate the Klamath River law being enforced extra-jurisdictionally? So outside of reservation boundaries against other activities? You may not be able to answer that at this point because it's not adopted. But is that something that's possible? Do you foresee that? And then the second thing is a general question about what do you see it as adding? I mean, why not pass a tribal constitutional amendment or a tribal law that recognizes tribal members' rights to salmon or the community's rights to salmon? Why isn't that? Why wouldn't that be satisfactory? What is the addition that rights of the river, rights of the Klamath River law? What are the additions that it gives to that? Why is it necessary to go above and beyond the human right component?
Yeah, so I guess first, and it's kind of adding to what Dean Warner was talking about, where what we are trying to do with this new law is strengthen our tools and abilities to use federal and state law when Yurok jurisdiction might not be the easiest to prove or might not be able to be proved at all. And so as you can see, like especially when really working in on the definition of a cultural landscape in the Klamath River, fitting that definition, that's going to be very helpful in National Historic Preservation Act claims, and also even more helpful under the California Environmental Quality Act that does explicitly acknowledge cultural landscapes as cultural resources that are to be protected under state law. And so by developing tribal law, it helps us utilize our sister jurisdictions laws to protect these cultural resources. And so that's what we're trying to do to, I guess, outside of Yurok jurisdiction, how this law will help inform and protect the river. For your second point, granting, or I guess codifying the rights of the Klamath River under tribal law, why is that, adding anything? And the way that we are viewing it is especially by the river having standing on its own to be in tribal court, allows the court to view the respondent's actions in a more holistic way, and how the respondent's actions are harming the cultural riverscape as a whole versus tying it to an individual or the government and how that individual or government is being harmed. And so by adding this kind of more holistic view and landscape protection type lens, that allows the court to flexibility in what remedies to grant for that harm. And so we are hoping the court will take that up and really think about what type of remedies that they can order that would ensure the landscape as a whole is being protected and being made whole after bad actions and from any respondents.
So we haven't, thank you for that, Geneva. We have another 3 or 4 minutes here. I just wanted to ask both of you a very quick question that has little to do with the jurisdictional issues or the macro issues, but what gives you hope nowadays? I mean, things are so bad. The salmon run is almost non-existent in the Klamath River now, as I understand, last season. Things seem to be going perpetually downhill. What gives you hope at this point? Is it the expansion of this new platform of tribal environmental law? Is it the civil disobedience that's beginning to occur on a wide scale? What gives you hope? I'll start with Geneva. What gives you hope today?
Oh, that's a hard question. I guess what gives me hope is seeing the community that I serve and that I work for really stand up and push to protect salmon and the river and just Yurok natural and cultural resources as a whole. Every time I show up to work, I just see the energy and drive to ensure that protections are in place and that these natural resources are being protected. And I guess the reason why that gives me hope is because I know the Yurok people have been doing this since time immemorial, and they will be doing it far into the future. This isn't a new fad. This is the way the Yurok people live their lives and the way that the Yurok government was formed to ensure that those protections keep moving forward. And so I think the reason why it gives me hope is like I am playing a role in that, but when I leave or when I'm no longer in this position, I know that that work is going to continue moving forward, and that the little bit that I did is going to help the Yurok people achieve their goals and protect their natural and cultural resources. And so I think that idea that this is a forever thing, a forever movement forward is very hopeful for me.
Plus, you were absolutely sure when you went into practice that you would be working on a rights of nature law.
Yes.
So Dean Warner, last word for the panel. We still have a couple minutes, but what gives you hope? You see into a bunch of different universes, and so what gives you hope?
Geneva. And the Yurok Tribe. And I think what Geneva and the Yurok Tribe are doing is an example of something really exciting that's happening not just in the United States, but we're seeing it across the globe, which is Indigenous communities coming up with really creative solutions in ways of effectuating their environmental ethics. And so I really applaud Geneva and the Yurok Tribe for the work they're doing and think it's an example of a great trend. Secondly, like Geneva, I am really inspired by this generation behind us. I had actually heard from a Lakota elder that my generation was the 6th generation, and it was the 7th generation, so the generation behind us that's really supposed to change the world. And also that a white buffalo had been born kind of contemporaneously with the start of that 7th generation. And I think we're seeing it. Well, civil disobedience and protests can be difficult and disheartening. We also know historically that following these eras of protest are profound change. At least in the United States, we've seen that, that we don't really see the legal change until society rises up and tells us that we need that change. And so I take hope in that history that although this is, at least in the United States, a difficult and trying time, that our history tells us that we should start to see change. And I think we can see in Indigenous communities that has happened. So the Idle No More protests in Canada, the Dakota Access protests in the United States, these are all protests that, while difficult and trying, certainly at the time, led to systemic change. And so I think that we can have hope. I think there is hope. Sometimes change is difficult. I think we're in the middle of a place of change, but I have great hope. And I know that 7th generation that's coming up behind us are really going to be the change makers and are going to make our society that much better. And our job is just to not be obstacles and to help them along.
Great. So we need to wrap it up, but I'd like to thank the two of you for carving out time to do the presentations and the discussion, and just to thank you to the two of you for the work that you do. Next up is the Oceania panel, to be moderated by Erin Daly of Dignity Rights International and Widener University Delaware Law School, with panelists Michelle Maloney of the Australian Earth Laws Alliance and Catherine J. Irons of Victoria University of Wellington in New Zealand. But before we get to them, we'll be taking a 15-minute break, and then we'll reconvene with that panel. So thank you.